I have the privilege of serving as a crossbench member of the Joint Committee on Human Rights, which was referred to by the Noble Baroness Lady Chakravarti during her remarks, and indeed she referred to the 50-page report that was finally agreed by a majority in the committee. It's a majority, not unanimous, report on February the 7th, and as others have said, it was published today and is available in the printed paper office. I'll say, if I may, in my remarks, something about what it has to say about safety. But first, before doing that, I'd like to agree particularly with the tone of many of the contributions that have been made so far on this group of amendments. My noble friend Lord Hannay, as always, put his finger on our international obligations, not least amongst which is the 1951 Convention on Refugees. Now, it may well be, but this isn't written in stone, that there should be attempts to try and change and reform this in the climate of today's demands. I'll happily give way.
The noble Lord Alton for giving way, and he has just referred to international agreements. Would he agree with me, therefore, that this bill contravenes international agreements like the UNCHR, but also the ECHR? And I am reminded of the fact that the provisions of this bill extend to Northern Ireland, and hence this provision and this bill undermines the very basis of the Good Friday Agreement.
Well, I'm very grateful to the Noble Baroness. I wasn't intending to touch on Northern Ireland, but the Noble Baroness, Barry Ritchie of Downpatrick, is right that this does touch on the Windsor Agreement and on our obligations to Northern Ireland, which are separate from those of the rest of the United Kingdom. And I would commend that section of the report, not my opinions, but the report does touch on that question. But she also asks about our other obligations. There are many obligations that we have, not just in the Refugee Convention, but the ECHR she's just referred to, and yes, we have obligations there too. And of course, the government on this bill, as on the illegal migration bill, declined to give it a compatibility statement because the government itself cannot say that it will be compatible, although ministers I know take a contrary view that there is uncertainty around that. But if there's uncertainty, then one must be very careful where we tread. I was very struck, though, on the issue of our international reputation by the statement that was made by the former Pakistan Prime Minister, and which is referred to in the JCHR report, who justified what he was intending and has done in sending back 430,000 Afghan refugees to Pakistan. He said it was modelled on what we were seeking to do here in the British Parliament. So even though we know that that's casuistry, it's extreme, nevertheless we can see where this argument can lead and the way in which it can be used. So yes, our international reputation, as the noble Lord Hannay said, he is right to say that it can very easily suffer. The Right Reverend Prelate, the Bishop of Southwark, was, I thought, also got to the heart of this when he said that legislating that Rwanda is safe doesn't make it so, and the noble and learned Lord Faulkner of Orton touched on that same point. Just saying that an apple is a pear doesn't make it such. Saying that a dog is a cat doesn't make it such. It may be your opinion, but it isn't true. And that is surely what we have a duty to try and do in this place. My Lords, process, procedure, governance. During our debates on the illegal migration bill and on the treaty, I complained that we had not been treated properly as a select committee in the way that you would expect select committees to be treated. Suella Braverman, the then Home Secretary, declined to appear before the Select Committee. We didn't see James Cleverly in the context of this bill. We did, however, see the Lord Chancellor, Alex Chalk, and I pay tribute to him and the way in which he delivered his evidence and took the questions that we put to him. But as the noble and learned Lord has just said to it, it is the duty of the Home Secretary of the day to explain what the intentions of their legislation is. And if there is anxiety about something like as important as compatibility statements, for them to explain why they feel unable to give it. My noble and learned friend, Lord Anderson of Ipswich, rightly said that we are ill-equipped to make these kinds of decisions in Parliament. I didn't serve as long as the noble Lord Howard, although we did have the distinction of contesting the same parliamentary seat in the heart of Liverpool on separate occasions, or indeed as long as the noble Lord Hailsham. But I rather agree with what the noble Lord Tugendhat said to the House a few moments ago about the way in which legislation was and has traditionally been dealt with both in another place and here. I cannot remember select committees being treated by secretaries of state in the way that I've just described, and thinking all the way back to the 1981 Nationality Bill, on which I spoke many times, there were opportunities to hear the arguments, to discuss the implications, and to make appropriate amendments. I have not felt that about this legislation or that which preceded it. I think it's been pushed through in a pell-mell way, bringing to mind the thought that if you enact legislation in a hurry, then you will end up repenting at some leisure. My Lords, let me take you for a moment, if I may, to page 15 of the report, because this comes right down to the role of the UNHCR and safety. As of January 2024, as recently, therefore, as last month, UNHCR had not observed changes in the practice of asylum adjudication that would overcome the concerns set out in its 2022 analysis and in the detailed evidence presented to the Supreme Court. The Supreme Court, not the House of Commons, not the House of Lords, relied on UNHCR when it came to a decision about questions of fact. Let me quote again from the report. UNHCR notes the detailed legally binding commitments now set out in the treaty, which, if enacted in law and fully implemented in practice, would address certain key deficiencies in the Rwandan asylum system identified by the Supreme Court that would, however, require sustained long-term efforts, the results of which may only be assessed over time. Well, clearly we haven't had the time to make those assessments, and again we are being urged to rush pell-mell. Two witnesses, and I won't detain the House much longer, Professor Tom Hickman, KC, said this to the committee. Parliament is effectively being asked to exercise a judicial function, to assess evidence, to look in detailed facts, and effectively to distinguish the Supreme Court's judgment, to say that things have moved on and it's not binding on Parliament. I don't mean in a non-legal way, in making its judgment. In my view, he said, that is an inappropriate exercise for Parliament to conduct. It is a judicial function. This was a view echoed by Professor Sarah Singer. I'll just read from paragraph 57, one sentence. To contradict the Supreme Court in this way is perhaps not showing the respect to the court that should be owed as a constitutional principle. And my Lords, in the summary on page 35, I will conclude with this. We've considered the government's evidence that Rwanda is now safe, but have also heard from witnesses and bodies, including the UNHCR, that Rwanda remains unsafe, or at least that there's not enough evidence available at this point to be sure of its safety. Overall, we cannot be clear that the position reached on Rwanda's safety by the country's most senior court is no longer correct. In any event, the courts remain the most appropriate branch of the state to resolve contested issues of fact, so the question of Rwanda's safety should best be determined, not by legislation, but allowing the courts to consider the new treaty and the latest developments on the ground. My Lords, for all those reasons, I believe Lady Chakrabarti has done the House a great favour in bringing these committee stage amendments to the House. She's already shown her willingness to think further about whether they might be applied in other ways. That's what committee stage is surely all about. And I think that the tone that's been struck in the course of this debate is one which behoves members of your Lordship's House to think very deeply, and I would commend this report to the House.